Thank you. It's great to be here. As Diane said, I'm Trip Van Oppen. I'm the president of Earth Justice. I'm going to speak for a few minutes about climate law, and then I'm just really speaking to introduce a panel that's going to talk about where things might need to go in the legal world to fully address climate change. We have a lot of important things going on today on climate change, but not enough. And so my purpose is to give a little sort of what's in the landscape and what's the update, and then turn it over to a panel who are each bringing their own ideas to that topic. First of all, who's Earth Justice? Just a brief moment on that. Earth Justice is an environmental law organization. We work around the country defending both the planet and people's healthy communities. We work on the big issues of our time, including climate change and energy, including protecting wildlife and public lands and oceans, and also including preventing the ways in which we're poisoning ourselves through air pollution, water pollution, pesticides, toxic chemicals. We have, like I said, offices around the country. One of them that works here in the Rockies is located in Denver. The Denver office has long worked on public land protection, protecting roadless and wild areas of our national forests, working today as part of the team that's trying to protect the Thompson Divide that was talked about in the last panel a few moments ago, and the Rhone Plateau a little bit west of here, but also working on clean energy issues and on dirty energy issues. So we're doing an increasing amount of work in the Colorado Public Utilities Commission on promoting solar energy through the legal process that takes place in the Utilities Commission. So what's going on in climate law in the United States? A lot of really important stuff, mostly happening in the courts and in the regulatory agencies. It's traditional regulatory process to develop, mostly led by the EPA, to develop rules that apply to the power system to reduce regular pollution and greenhouse gas pollution. That regulatory model is leading to a lot of retirements of old, dirty, coal-burning power plants, which is reducing our carbon emissions in the United States pretty rapidly. There's a lot of chatter in the political discourse, in the news media, in the blogosphere that says, you know, EPA shouldn't be doing this work. EPA doesn't have the authority to do this kind of work. Why is EPA regulating climate change when the Congress never directed them to do that? So I want to perhaps put your minds to rest that that's a lot of relatively meaningless political chatter, in the sense that the Supreme Court in the United States has repeatedly said the EPA has this job to do, should be doing it, and now that they are doing it, has affirmed their right to do it. In fact, there were two really important U.S. Supreme Court cases on this very topic this year. One this spring that was upholding EPA's use of computer models and of its Clean Air Act authority to require states to reduce the pollution that was originating in their state that was harming air quality in downwind states. It was a decision that was hard fought by the utility industry, and one of the reasons that there are two reasons why it's really significant for the climate debate. One is the Supreme Court said the experts at the EPA have the knowledge and the computer modeling to be able to make the determinations that are very complicated on how much pollution is originating in one state that's making it difficult to meet public health standards for air quality in downwind states. And the utility industry had challenged that, said, no, you need to fly spec this much more. We're not ready to sort of technically capable of making those determinations, and the Supreme Court upheld EPA's action on that in that regard. Second, they said if the states don't do the job, the EPA has the authority to step in and do the job. And that's really important because as the agency now moves towards adopting greenhouse gas controls for power plants, some states are resisting. They're treating it like they treated the Affordable Care Act and saying, we're going to opt out of this system, we're not going to participate. They want to be resistors. There's a lot of sort of Tea Party rhetoric that says we should resist this EPA initiative just like we resisted Obamacare. Well, the Supreme Court has made it clear that the EPA has the authority to come in and make the requirements, put them in place if the states opt out. So it's crazy for a state to opt out, because what they're doing is buying themselves a plan that will be prepared by EPA rather than by their own people. And there was an interesting little twist on that in Virginia when this was all beginning, which was the sort of Tea Party-controlled legislature in Virginia said, we're not going to stand for this EPA system. We're going to opt out. We're going to resist and opt out. And the biggest utility in the state came to the legislature and said, are you crazy? Don't you realize what that means is the EPA is going to write our plan? So, you know, it's not like Obamacare where you could just opt out. It's federal authority at work. So that traditional regulatory model of using environmental laws and using the authority of the EPA is a major piece of what's going on in climate law, and it's taking court case after court case to drive it forward. It's not really happening on its own momentum on the political process. We'll come back to that in a moment. The second major area of work that's newer, less well known, it's not generating big U.S. Supreme Court cases, it's not generating big debates in Congress, but it's taking place state by state, almost like trench warfare. That's in the state public utility commissions. Because we have a vacuum of federal policy on most of these clean energy and climate issues, the states have to do the job, and their utility commissions are really where a lot of the rubber meets the road. They're making decisions on a state-by-state basis of how much renewable power is going to be required, how are utilities going to be paid for what they sell back to people, how are people who put solar on their roofs, businesses and homeowners, going to get paid for that, what they produce. How's the grid going to work when we start having more and more renewable energy on it and when we have storage, electric storage capacity on it? All those rules of the road right now are being written primarily at the state level, state by state, at the Utility Commission, which has been something that happens generally outside the public eye. So we at Earth Justice and many of our allies around the country in this battle are doing an increasing amount of work in the fairly low-profile, highly technical, grinded-on battles that are taking place in the Public Utilities Commissions. Important results are happening there. We're involved in a case in Colorado right now, for example, where the Colorado Commission is determining what is, quote, the value of solar. What will producers of solar energy be paid by utility companies for the solar power that they produce? And that makes a huge difference. How that price is set makes a huge difference in how fast solar will be deployed, how many people are going to invest in it, how many businesses are going to invest in it, what's the payback period on those investments. And the utility company is saying basically you should have to sell all your power to the utility. You shouldn't be able to use it yourself and sell just the surplus to the utility. That would be a huge disincentive for people. And so we've had some good results so far in preliminary stages of that case here in Colorado, where the recommended decision that's going to the full commission for a ruling now is that the utility's wrong on that. That producers of solar power at the residential level, at the commercial level, should be able to use all the power that they want, not have to sell it back to the utility. The third area of law that's developing is what is the non-government, non-regulatory law. It's where people are trying to think about the cases where they go directly against the carbon emitters themselves. This is when people have for a long time been thinking about what can we do in climate change that's like what happened with tobacco. What's the big, quote, tobacco-style litigation that somebody can bring? And that means trying to put all of the big emitters into one courtroom and hold them responsible for the damage that they're causing. Those kinds of cases have been, early versions of those kinds of cases have been tried. They're basically moonshots at this point. None of them have been successful so far. But the couple of examples are, one is a village in Alaska called Kivalina. It's on the northwest coast of Alaska. The whole village has to move away from its current location because of sea level rise, coastal erosion, permafrost melting is physically destroying the village. And it's a village without the financial resources to make that move. So they brought a case, as their local government, brought a case against all the big oil, coal, and utility companies in a courtroom, saying basically, you're responsible for this. We shouldn't have to plead to to the federal government or the state government to pay for this. You should pay for it, and a court should make you pay for it. And the case was thrown out of court, saying basically, this is all about who's got what obligation to address climate change. And I, as a judge, the judge said, I'm not the person equipped to do that. I'm not the one with the authority to do that. We're not going to hear the case. There was a similar case brought by people who suffered financial damages after Hurricane Katrina along the Gulf Coast. They said, again, suing all of the big emitters, saying, it shouldn't be the responsibility of FEMA to clean this up. This is the responsibility of the oil and coal and utility companies to clean it up. And similarly, their case was not successful. And then I was on a panel here at this conference a couple of years ago with a law professor from the University of Oregon named Mary Woods, who was orchestrating with many, many people around the country the effort to bring cases which would establish the principle that the atmosphere is public trust, that the government has to protect the atmosphere as the trustee of that trust, and that climate change, the government therefore has an obligation to act on climate change far beyond what they've currently done. They brought cases under many state laws and some federal laws trying to establish that principle. So far, most of them have not been successful and have been dismissed. A few of them are still perking along. So what are the takeaways about current legal strategies on climate in the United States? First of all, a lot of progress is happening. We are retiring dirty old coal plants. We are expanding renewables. We are getting better at efficiency, as many, many speakers here at this conference have talked about. That it's requiring legal challenges day to day to make that happen. It's not happening through policy leadership in the Congress, which is totally gridlocked on this issue. It's happening through a lot of legal challenges, and the litigation capacity remains very, very important. But it's also true that we don't have all the legal tools and legal concepts in play that we need. And there are ideas from other parts of the world. There are ideas from legal scholars about what we should be doing, and that's what the purpose of our panel that's about to start up is to bring before you, is some of those ideas. The United States does not have in its Constitution the right to a healthy environment. We have the right to free speech and the right to exercise religion and many other rights. We don't have the right to a healthy environment. Most of the world today, most countries in the world, the vast majority of countries in the world today have institutionalized in their constitution or in their basic laws the right to a healthy environment. In fact, we stand out. We and just a few other countries stand out for not having that built into our constitution. Those countries all are the descendants of the English legal system. So the countries that don't have that are basically the United States, Canada, Australia, and the United Kingdom. The rest of the world has already recognized this. A lot of people are thinking about what's that going to mean, because it's been recognized in a lot of law, but it hasn't yet really been applied to the problem of climate change. It's very big uncertainty. What's that going to mean? There's a step that can take that even farther, which is that not only should people have a right to a healthy environment, but that nature should have rights that can be vindicated in court. And so one of our panelists is going to talk about that. Another thing about the United States law is we've got governmental powers and we have individual rights, but we don't have much recognition of community rights. It's something that we have with Native American tribes. There's tribal rights. But what about a neighborhood? Does a neighborhood have rights? And so we've got a panelist who's going to talk about community rights. And then we've got legal challenges that our current law is not prepared to face, but that climate change is bringing to us, like the effect of sea level rise on coastal counties where a huge portion of our people live and our economy takes place. And there are legal challenges to addressing adaptation to climate change, which we're going to tackle. So those are the kind of topics we're going to talk about now. I want to introduce the panel members who will join me on stage at this point, I think. At least I see most of them. I want to introduce, why don't you come on up and we'll introduce them. Which is it? Just right there. That's fine. Well, I'll sit on the end. I'm going to introduce the panel members all right now. They will each speak for a few minutes in succession, and then we'll have some back and forth discussion, and we will leave time for your questions, which are really important here. So I'm going to start at your far left, my far right, is Albert Slapp. Albert is a noted environmental attorney, longtime from Florida, where many of these sea level rise issues are being addressed in a pretty frontier and path-breaking way. He's now a resident of right here in Aspen and Snowmass, and he is the president of the Coastal Risk Consulting firm. Next, Bob Goff. Bob is the secretary of the Intertribal Council on Utility Policy, frequent presenter here at this conference in past years. And then to the closest to me, Osprey Ariel Lake, the founder and president of the Women's Earth and Climate Caucus, and a leader of the Global Alliance for the Rights of Nature. So I'll turn it over first to Osprey.
I want to talk about rights of nature. And I think we live in a really remarkable time that has so many dangerous consequences, but it's also an opportunity. And from a sustainability perspective, I think we need to really question our economic and legal frameworks regarding the natural world. And I really appreciate all that you said, and I'm glad that we have all the legal components in place that we do. But I really want to talk about something that might seem sort of revolutionary or different about giving nature rights. And given this transformative time and really the urgency of the multiple crises that we're facing, I think we have to really reevaluate the very foundation of our legal frameworks and our economy, because obviously they're not working. So in addition to many of the groundbreaking ideas that we've heard the last few days, I think we also need to look at a foundational level about what we're going to do about systemic change. And what I like about the work of Rights of Nature is it can address both short-term immediate needs at the community level, but it's also a way of viewing a long-term change, which I think addresses the systemic problems that we've gotten into. So after decades of environmental protection laws that we've experienced, which have really achieved some very good successes, our modern legal systems have really failed to prevent the increasing grave threats of climate change and degradation to our Earth's ecosystems, and also the growing displacements of people around the world and other species. So to truly live sustainably and live in harmony with the Earth, I think we need to look at the very DNA of our legal and economic frameworks. And I think this is how we're going to really address a new way of being with our Earth, with each other, and respecting natural law. Because right now our economy and our legal frameworks do not adhere to the biggest law of all, which is Mother Earth's law. And that is a gigantic problem that's been going on for, decades. Modern civilization does not respect Mother Earth and her laws. So the majority of the world's legal frameworks right now are based on treating nature as property. And this is one of the biggest problems. As soon as we stop seeing nature as its own entity but put nature into a property framework, we began to develop some really big problems with our human relationship to the natural world. Our life-giving rivers, forests, and mountains. Our mountains are treated as property to be sold and consumed, and they're often protected under commerce laws. As properties, these natural communities and ecosystems are not recognized as rights holders, and in our legal systems, because nature is property, it really doesn't have standing in a court of law. By adhering to the current structure of law, we are actually furthering a dangerous human relationship to the natural world and ownership and exploitation. So there's a growing global movement about advocating that we need an entirely different legal configuration that recognizes the Earth's living systems and that they are not enslaved property under humans. Just as we have legally understood it is wrong for men to consider women property, it is wrong for one race to enslave another and claim them as property, so it is wrong for humans to have dominion over the Earth and see nature purely as property. And if you think about it, if this constructs that we have, like seeing nature as property, were working, I don't think we would be in this climate crisis, and I don't think we'd be experiencing this much environmental degradation. Our current structure of law calls for environmental regulations, and these regulatory laws do just that, because that's what we have in this country. And what happens with regulation laws is they do exactly what they say, which is regulate how much harm and how much damage can happen. And we get permits for how much we can damage the ecosystem. This is very problematic. The laws do not actually stop pollution and environmental destruction, but they regulate how much harm, as I said, can occur. At best, they slow the level of environmental degradation, but they don't stop it. Environmental laws in the U.S. were passed under the authority of the Commerce Clause, which grants exclusive authority over interstate commerce to Congress. Treating nature as commerce has meant that all existing environmental laws in the U.S. operate under the concept of nature as property. And one of the systemic changes that we can make, not just in the U.S., but also worldwide, is to move from a property-based legal framework to a rights of nature framework, whereby nature is recognized as a rights-bearing entity. If this happened, activities that harm the ability of an ecosystem and natural communities to thrive and naturally restore themselves would be in legal violation of nature's rights. And this is not some fantasy. These kinds of things are already going on. Organizations like the Community Environmental Legal Defense Fund, the Global Alliance for the Rights of Nature, which I'm a part of, the Rights of Nature program at Global Exchange, and our organization, the Women's Earth and Climate Action Network, are actually working with communities to change the law. This work involves changing local laws to recognize that natural communities and ecosystems possess the fundamental right to exist, flourish, and that residents of these communities possess the legal authority to enforce those rights on behalf of the ecosystem. And yes, we have been implementing these laws, and we have won. In 2008, the community of Tamaqua Borough, Pennsylvania, passed an ordinance recognizing nature as a rights-bearing entity. Since then, over 24 communities in the United States have passed local ordinances which recognize rights of nature, protect their ecosystems. Local rights of nature ordinances today are protecting communities from harmful practices such as shale gas drilling and fracking. So this is a way for a community to say, we have the right to protect our water systems, and we don't want fracking in our community, and they are able, through writing their own local ordinances, to be able to protect their community. Destructive corporate activities that directly impact a community can be stopped as rights of nature are raised above corporate rights. We can change our laws if you think about civil rights, suffrage, and the end of apartheid. And we really need to see this differently, because in the rights of nature framework and community rights framework, we actually can trump state law and corporate rights and corporate personhood. And this is an incredible tool that we're seeing being used all across the country. It's also important to know that it's happened at the national level. In 2008, Ecuador became the first country in the world to recognize rights of nature in their constitution, and that was a huge breakthrough for the movement. I won't go into a lot of detail to that because I don't want to take up too much more time, but additionally, Bolivia has established 11 new rights of nature laws. In 2012, New Zealand gave a river was legally declared a person with standing with the help of guardians to bring legal actions to protect its interests. So actually an entire river ecosystem was protected as having its own rights. Other work is going on at the international level, and currently our organization is working with the islands of Maldives, which are some of the lowest lying islands in the world. And we're looking at creating a right to climate case in the Maldives, which would then give them the legal opportunity to sue the international community for polluting the climate, which is, of course, raising sea level rise and basically dissolving the Maldives Islands and their existence totally. And we're looking at seeing what we could do to create a case not just with the Maldives, but a lot of island nations to the right to climate so that they would be able to go to the international community with their case. So I think this is a short-term strategy in terms of giving community rights to protect their local ecosystems, but I also see it as a long-term strategy because I think we need to understand that if we don't change our frameworks, then we actually can't get at the real problem, which is our relationship with nature. And I think what's exciting about the law, even though it kind of seems like a deadpan subject a lot of the time, is that actually law affects our cultural relationships. If you think about when we decided that it was no longer legal to have slaves, and how it didn't overnight end racism in the United States, but it began to give us a legal framework to do so. In the same way, if we start really pushing for rights of nature and making it illegal to destroy ecosystems, we can also look at the more ethical and spiritual understanding that we need to have right relationship with nature, which means just as we have human rights, nature also needs to have rights equal to human rights, and we can change that dynamic of dominion over nature into living in harmony and balance with nature. Thank you.
I'm an environmental lawyer and law professor, and the story that I'm about to tell you, I just want to set it up with going back to Hurricane Katrina and Sandy and the thousands of people who lost their lives, lost their homes, lost their livelihoods, because the story that I'm about to tell you about my last case against Miami-Dade County, the county that serves 2.5 million people, is instructive because 39 to 40% of America lives in a coastal shoreline county. Okay, 123 million of us live in a county that borders the open ocean. That's a lot of people currently at risk. And when you go back and you turn the clock back to who were the people who died, who were the thousands of people who died in Hurricane Katrina and Sandy, they were mostly elderly, poor, and minorities. So we're talking, and we've been talking for 3 or 4 days about reducing CO2 emissions and greening America, and we're all in favor of that. But in the meantime, how are we going to protect the least among us from the consequences, which the scientists say are baked into the system? That if we flipped a switch tomorrow and everything was solar and everything was wind and there was no more fossil fuel used in America, that the energy that has been trapped in the oceans will be causing sea level rise and damage and coastal impacts for the next 100 years or more. And this is what the scientists are telling us. So let me roll the clock back to 2012, when I was contacted by Alexis Siegel, who's the executive director of the Biscayne Bay Waterkeeper down in Miami. And that's a group that's in the Waterkeeper network. And she came to me and she said, you know, Albert, the sewer system down here is malfunctioning. We have raw sewage overflowing into Biscayne Bay. We have raw sewage overflowing into the Miami River and the canals. It's horrible. And can you help us? Can you help us bring a lawsuit against Miami-Dade County, another David and Goliath effort to get them to reinvest in their sewer systems? And I said, yes, Alexis, I've done this before. I did it in Philadelphia. I did it in Cincinnati. And in those two cities, billions of dollars flowed in, reinvestment into the sewer systems, tens of thousands of construction jobs. I know how to do that. I'm happy to help you do that. But when I got involved in the case, there's so much work to do in the beginning to understand the facts of all these large environmental cases. What I saw was that Miami-Dade County was ready to put some money into the system, but they wanted to do it on the cheap. They wanted to rebuild the system at the same level that it was today. Now, that would have been like after Katrina, the Army Corps of Engineers had come into New Orleans and said, hey, we're the Army Corps of Engineers. We're here to help you. We're going to rebuild your levees at the same level that they were when the waves crashed in at 14 to 16 feet above the levee. So, of course, they used a sea level rise model called the Army Corps of Engineers Sea Level Rise Model, and they built those levees 12 or more feet higher. And so what we realized was that we had to sue Miami-Dade County to get climate ready and storm safe with its critical infrastructure to protect the citizens from having their sewer system destroyed. Now, when you get up in the morning, if you're like me, you're going into the bathroom, you're going to flush the toilet, it's got to go someplace. You're showering, that water's got to go someplace. That potable water and sewer are two of the most fundamental parts of our critical infrastructure that is threatened in all the coastal areas of the United States and, of course, around the world. So how are we going to deal with this? Because the county was adamant, we're not going to use the Army Corps' sea level rise model in our basis of design. It'll cost us billions of dollars more. We can't do that. And yet, after Sandy, over 11 billion gallons of raw sewage flowed into the nation's waterways because those plants in the Northeast United States were hammered by 14-foot storm surges. They were just knocked out. So they were overflowing raw sewage for weeks and months afterwards. Do we want that to happen in Miami-Dade County? No. So I organized some of the top experts, academic experts in South Florida, from University of Miami, Florida Atlantic University, Florida International, and we inundated, no pun intended, we inundated the court and the county with expert reports of vulnerability, of sea level rise, of geology, of all the different areas of expertise that we needed. And of course, the county, and as Tripp knows, also being an environmental lawyer and in litigation for so many years, is who is this pipsqueak Biscayne Bay waterkeeper to challenge our authority and our knowledge of what we must do? You cannot do this. But of course we were in court, and we had submitted all of these great expert reports. So what happened was, behind the scenes, they said, oh, there might be something to this sea level rise thing, and maybe the Biscayne Bay waterkeeper and their experts and all these academics have an issue, have a point. So they went and they hired, behind the scenes, an environmental engineering firm by the name of Hazen and Sawyer to peer review the work that we were doing. And but they didn't count on two things. Number one, they didn't count on the fact that Hazen and Sawyer was working for Mayor Bloomberg after Hurricane Sandy to help him, advise him what to do with the sewage treatment plants in New York City. So that was a $20 billion program that Mayor Bloomberg was envisioning. They certainly weren't going to take a dive on behalf of Miami-Dade County when they were already doing the same kind of work for Mayor Bloomberg, number one. And number two, they didn't realize that in pretrial discovery we were going to get their peer review report. And of course, you know how this story ends. Their experts and our experts agreed. And I won't, belabor the story, but ultimately the result is that the basis of design of the new multi-billion-dollar sewer rebuild in Miami-Dade County is to use the design year of 2075, because these plants have a 50-year life, 3 feet of sea level rise, and a 22-foot storm surge. That these plants, the sewer system that serves now 2.5 million people and more people coming in every day, because it's on fire down there as far as development is concerned, 3 feet of sea level rise. And this is not the end, it's the beginning of getting our critical coastal infrastructure climate ready and storm safe before the next storm, and we don't have as many deaths, injuries, and damage to the environment that we did after Katrina and Sandy.
Thank you. I'm reminded of the old adage, there's 3 ways to do things: the right way, the wrong way, and the Army way. The Corps has smartened up quite a bit over the years. Hiring the right expert, I think, is a good thing. The Corps has smartened, I think, is a good thing. I think is a good thing. It is real. Humans have a responsibility for it. But not only do we deal with indigenous rights as a perspective, unalienable rights, but unalienable responsibility. We can't walk away from it. And when the climate scientists were saying at one point that the sun has a greater influence than we thought in the past, reducing human responsibility a little bit, he thought corporations might just take advantage of this, saying, see, it's not our fault, nothing we can do. He said, no, humans are the swing vote. We're the ones with the dog in this hunt, and we're the ones that are going to have to take some action. I'd also like to remember Randy Udall and Helen Cullenrud, the former mayor here, as great climate leaders. And there's something noted in the program for the 3 of them. How many remember this photograph? Okay. This is credited with changing human consciousness. We saw ourselves differently. We saw ourselves as one in space, in time, unified, no boundaries. It gave human beings a sense that we are all indigenous and perhaps endangered species on this planet. How many recognize this photograph? Only a few. This is a selfie. It's under litigation. And the litigation is who owns the copyright. This monkey stole the camera from a photographer who spent thousands of dollars to photograph this monkey, to go out and get it. Monkey took the camera, started snapping around, I believe something like 1,000 pictures, and most of them were of himself, smiling. And this is the best. And the question comes up, Who owns the rights, the copyright? The photographer didn't get to take the picture, the monkey did. And people using this saying public domain because the monkey took the picture, and of course the monkey couldn't own the copyright because it's an animal. It's a monkey, it's not a human. So when we start thinking about these roles of legal rights, and as Osprey was talking about how certain governments are now looking at trees and Mother Nature having standing, rivers. India has just given non-human personal rights to dolphins, that it's no longer legal to keep them in captivity for your entertainment. They're non-human persons. The Citizens United, just as a point here, we've got animals creating art, and the question of copyright comes up with, whether it's elephants doing paintings or orangutans or other animals doing these kinds of things. Let's just get to this. But this idea of ownership and property that we discussed, it's undergoing great changes. And we are in a civilization that is more known for expanding rights, whether the last 200 years from property-owning white males to women to people who are 3/5 of a person for population purposes under the Constitution. I litigated a case bringing intellectual property rights to one's name and image to Chief Crazy Horse in 1992. Up until that point, Native Americans did not have a recognized right of publicity in their own name or image. They were part of nature, just like everything else in the Americas, free for the taking. So we see an expansion of rights and hopefully of responsibilities. But one of the interesting things with Citizens United, it is in that same track of expanding rights to groups of people as corporations. Now, I haven't seen one die, and John Oliver points out that corporations should only be allowed to live for 77 years, just like any other human being, and have other liabilities, should be executed if they commit capital crimes. But there's the basis for Citizens United is the 14th Amendment, equal protection, that came out of the Civil War period, came out of the freeing of the slaves. You can't get to the 14th Amendment without going through the 13th Amendment, which says it's illegal to own persons. How many people are shareholders here in corporations? Round them up, please. They're all owning persons, apparently, under the law. We need to be thinking about this because we need to start finding that communities don't have rights under U.S. law as communities. Governments do, states, federal, county, city, and then individuals. But we don't have community rights. And we start seeing that in the Indian sector. And I want to put this up here for these photos here just to look at this. This is the diversity of housing types, homes. For 14 to 40,000 years of intricate fine-tuning using natural materials, 40,000 years of a green economy on this continent with great diversity, intellectual challenge, and challenges met. You can see it, it's around the entirety of the continent. Very different, but all workable. None of them today are legal in terms of code. And this is where we have Indian country today with legal housing. Basically, it's one house size, sort of fits all. HUD puts it out. We've changed a bit since the 70s, but this is sort of that same hallmark, that canary in the cave. This is, we follow code. We follow building codes, and they're very good. They've got a purpose. And my good friend David Eisenberg put this out some time ago. He says, let's look at building codes, for example. And what are they designed to protect? Fire safety, structural integrity, egress, lighting, ventilation, heat, water, wastewater, electric and gas, energy efficiency. And they do it pretty well. So much so that most of these things are no longer threats to our health and our safety and our well-being. But we've come to a time where we realize that there's a lot of other risks that meeting that inner circle exports, externalizes to the outer environment with the materials that we use, the resource depletion, the dependence on non-renewable energy, loss of habitat in the area, sprawl. Nothing in the building codes really, I mean, you may have to go to the zoning codes about sprawl. But the point is, we're going to need to be looking past the kinds of things that we've done, the regulations that we've put into place, and realize that we no longer live in the world that produced those sets of regulations and those rules. And we can go to the great climate cases as we're going to start seeing them come, but there's the small things that can be done in our hometowns in terms of changing some of these regulations. Just to point out one in terms of water in particular, there's always provisions in the codes and regulations that can be updated or out of date and need to be revised. Greater water, energy, resource efficiency, or new knowledge about health and performance concerns. Plumbing codes and public health regulations require that all water used in buildings be potable water, and that all used water, including gray water, be treated as though it was raw sewage, black water. We can look at that and say, I mean, there's some people who are suggesting the best investment every community can make in the West, at least, is water recycling plants. Because water is renewable, you can use it a couple of times, and we may be coming to that more and more. But the idea of requiring that all of our gray water gets mixed with, and portable water, gets mixed with what little black water a house produces, and making an abundance of black water, which then require more costs for treatment and the like, that is not a solution, and we need to be rethinking that. Just as we need to rethink the infrastructure changes. We don't build to the past, even though that's what insurance companies will reimburse you for. They'll replace what you had. They won't necessarily give you something better, more durable, more resilient. So I just wanted to put those points out and leave you with this. Orville and Paula had to leave. We're going back for services for the elder that Chief Looking Horse mentioned today, Rosalie Little Thunder. But they're planning World Peace and Prayer Day for next year. It's always on the solstice. It'll be the 15th, I believe, or 20th, World Peace and Prayer Day. In our discussions this morning, Chief Orville Looking Horse and Ted Turner were talking about World Peace and Prayer Day. And Ted invited the chief to consider one of his ranches as a site for World Peace and Prayer Day. And we've talked with Laura and other members of the family, and we're delighted at this prospect. We have a date fixed. We don't know just where it may be, but I just wanted to let you know there is a real tangible outcome and a meeting of the Turner clan, if you will, and the Lakotas who've been coming here for 11 years. We may see a great opportunity for closer collaboration in the years to come. Thank you much.
I would love to sit here and have a how do we get from here to there discussion, law school seminar, et cetera, with all three of the panelists. We can't do that. We're out of time for that. But I want to just see if there's any couple of questions from the audience before we close. One over here.
Hi, Mr. Slapp. I'm Chris Jacobson. I'm on the town council in Snowmass Village. I don't think we've met before, so it's great to meet you. I think it's fair to say, from most of the information that we have, everything that we do is interconnected. Everything that we do in one community is affecting another community. In that regard, I wanted to open an offering to you that as Snowmass Village, Rick Heedy was here speaking. I think he's a very competent person who's done a carbon footprint report for Snowmass Village. I'm sorry to say, as we move forward with Richard Goodwin's plan and other people to try to become the greenest village, we're right now have the highest and most reprehensible carbon footprint of most of the mountain communities around us. And as one of our community members, I wanted to just offer, I hope that you'll be engaged, and I hope that you might come to us as council members and explain to how our actions in this little community might be affecting all of your work in Miami.
Thank you.
Thank you.
I
One last
accept.
question before we get
Accept.
hooked off the stage. Any one more last question? Was that a hand in the back corner? No? Okay. Thank you.
Thank you.